Oh, there we go. Thank you. Good evening, everyone. Welcome to Aurora's Committee of Adjustment meeting. I will start by introducing the members of the committee and staff. I am the committee chair, and my name is Tom Plamondon. The remaining members of the committee are as follows. To my left is Michelle Boyer, the vice chair of the committee, Clarence Louis, and lastly, on my far right is Daniel Lajeunesse. The secretary-treasurer is Antonio Greco, and the planner this evening is Matthew Peverini. For each application that will be considered tonight, the following process will occur. I will briefly outline the purpose of the application or applications, and then the applicant or agent will then be given the opportunity to make a presentation. However, one is not required. It is the applicant's decision whether they wish to speak or let the application proceed on the merits of the information as received. Following any initial comments from the applicant, I will invite members of the public who have an interest in the application to come forward and address the committee. Those members of the public who wish to speak must clearly state their name and address and sign the corresponding request for notice form on the table in front of you, and it's to my left here. After completing the form, please hand it to the secretary-treasurer. Each individual may speak only once on an issue, and once discussion has commenced in respect of a motion, no further presentations shall be made. If you require any assistance with regard to visual material or technical assistance, please let me know before making any presentation. This is a public meeting. It is being audio and video recorded. Your name, address, comments, and other personal information are being recorded according to the Municipal Act and the Municipal Freedom of Information and Protection of Privacy Act. This will help our town clerk prepare accurate minutes and to create a record that is available to the general public, including on the town's website. Any questions about this collection should be directed to the town clerk. Please be advised that the reports being considered tonight are available on the desk in front of you, again on my left, your right. Should you wish to receive notification of the decisions for tonight's meeting, please complete the form. Owners and agents will automatically be notified. Please ensure that all questions and/or comments are directed through me as the chair. If relevant, I will request the appropriate person respond. It should be noted that the applicant will be given the opportunity to respond to any question or comments should the committee feel that it is appropriate. So with that, I will move to the agenda for this evening. And I will ask members of the committee for a motion to approve the agenda. Daniel?
Through the chair, I move that we accept the agenda as set.
Thank you. I'll look for a seconder. Michelle, thank you. And all in favor? Carries. Thank you. And I'll ask committee members for a declaration of pecuniary interest and general nature thereof. Are there any? Seeing none. Terrific. Thank you. So item 3 on the agenda, adoption of the minutes. So this is the Committee of Adjustment minutes of November the 14th, and that's meeting number 19-11. I'll look to the committee for adoption of the minutes.
I move for the adoption of the minutes for the Committee of Adjustments meeting number 1911.
Thank you very much, Clarence. Seconder? Daniel, thank you very much. All in favor? Thank you. Okay, so we'll move now to the presentation of applications. So the first one this evening is minor variance application for 2573342 Ontario Inc. This is 107 Ridge Road, And these are file numbers MV 2019-25A, B, and C. So the application of these three minor variances, the applicant is requesting relief from the requirements of the town's comprehensive zoning bylaw 6000-17 as amended to authorize the placement of fill and site alteration on the subject lands. The relief that is being requested are as follows. In A, section 14.1.2, subsection II, specifies no development or site alteration shall occur on lands within a key natural heritage feature without an amendment or relief from the zoning bylaw. The applicant is proposing to fill areas on the subject property. In B, section 14.1.4I specifies that no development or site alteration shall occur on lands that contain a significant woodland feature without an amendment or relief from the zoning bylaw, and the applicant is proposing to fill areas on the subject property. And finally, C, section 14.4.1I specifies that the net developable area of the site that is disturbed in Category 1 landform conservation shall not exceed 25% of the total site area. And the applicant is proposing a total disturbed site of 43%. Moving through department and agencies circulated, the building division, I'll just go through the essence of this comment, and it's every sewage system shall be maintained so that the construction of sewage system remains in accordance with the basis on which the construction and use of the sewage system was approved or required under the Act or predecessor legislation as the case may be, and 2, or double I, or the requirements of the manufacturer of the sewage system, and B, all components of the sewage system function in their intended manner. Placement of fill material over the septic sewer system or any component including the septic tanks shall be assessed by suitable qualified person prior to work commencing. The assessment shall be brought to the attention of the town for review, and a permit may be required for any changes to the septic sewage system. Engineering division, they recommended 2 conditions. The pre-site alteration drainage pattern shall be maintained, and 2, any changes due to site grading works shall not cause any adverse impacts on neighboring properties. Operational services, I'll just go to, in view of the above, staff recommend the committee impose the following conditions in the event that this application is approved: that the owner be required to provide vegetation compensation and a replanting plan in accordance with the Town of Aurora tree removal, pruning, and compensation policy to the satisfaction of the Director of Operational Services as compensation for trees removed or impacted by the fill project. Tree planting will be accepted for the trees removed as per compensation policy, and financial compensation will be provided for the trees still standing but suffering irreparable repair. That the owner shall agree to comply with the town tree permit bylaw number 5850-16 prior to the removal of any trees on the property in the future. And all of the above shall be included as terms and conditions in a letter of undertaking with the Town of Aurora to guarantee compliance with the conditions of approval and all related site works. Central York Fire Services, no comments were received. Legal Services, no comments were received. and I should qualify the fire department as well, at the time of writing of the report. The region, no concerns with the variance. Lake Simcoe Region Conservation Authority, the subject property is located entirely outside of an area that is governed under Ontario Regulations 179-06 of the Conservation Authorities Act. As an advisor to the town on natural heritage matters and conformity under the Oak Ridges Marine Conservation Plan, the LSRCA is reviewing the NEH. So at the time that this report was prepared, LRCA was still in the process of reviewing the NHE. Preliminary concerns have been noted regarding more detailed required on impacts to the key natural heritage features and appropriate avoidance mitigation and restoration measures. Those are the comments. So I am going to, at this point, then ask the applicant and or agent if they wish to address the committee.
I'm the applicant's agent. I'm the environmental consultant that prepared the NHE, and been working with the town of Aurora and our client on this issue. This is a bit of a tricky application because the works had already completed. So he had done the work, I guess didn't realize that he had these bylaws, so we were working with the town to sort of correct that. We met with the township as well as Lake Simcoe around, I think it was close to this time last year or early last year, to go over the concerns. We did our best.
I'm sorry,
Yeah.
this time last year, so that would be
I think it was, sorry, it was, I think it was March.
2018?
Yeah, sorry, I think it was March of this year, sorry. It's winter, it's cold. Of this year.
Okay.
And I had worked over the course to try to determine the amount of fill that was placed and some of the additional information that was being requested by the town and the Conservation Authority. We worked with them to prepare the NHE as well as the restoration compensation plan that was provided in our report, and look at the impacts for that adjacent woodland and the trees on site. And what we determined, as outlined in our NHE, is that the environmental effects are very minor with the placement of fill. There's some placement of a soil on some of the tree roots, but we felt that with the restoration plan that we could correct those issues. We unfortunately do not know how many trees were actually removed. We can only go by stumps and aerial photographs. So that is how we determined with the township the amount of trees. So we figured based on the size criteria that we're looking at approximately 15 or so trees that were removed, and we provided compensation requirements in our NHE for that. Do you have any questions?
Okay. I think we probably will, but I'm just going to ask if that concludes your presentation. Thank you. I'll ask if there are any members of the public here who wish to speak on this particular application. Good evening, sir. Welcome. I'll just ask the agent to have a seat for a moment or two. And yes, if you could start.
My name's Tom McGinnis. I'm the neighbor across the street.
So your address is?
134 Ridge Road. And I just became aware of this recently, so I just got this report now, so I'm kind of reading it in the last 10 minutes. I guess one of my big concerns is the drainage. I know the changes in the topography and the tree cutting are a foregone conclusion at this moment, but the drainage seems to have been altered. And the way the drainage was there before, there was a bit of a low area in between. Let me see on the drawing here.
If you want to put that up on the screen there, we can
Sure.
have a look at it with you.
So, this here is the new road that was put in by that new subdivision. The amount of fill they put in actually exceeded the RNCP guidelines. I was involved with trying to control the amount of development that went on that property, and also the fact that that property also didn't meet the guidelines in the Oak Ridges Moraine Conservation Plan, contrary to what the planner said when he came to the meeting. But it is what it is. What they've ended up doing is they raised the grade an enormous amount. At that time, this home, which wasn't owned by the present owner, there was another fellow that lived there. He didn't step forward and complain, but I really feel something wrong was allowed in what they did beside his property. They basically put a wall and raised his property very high. Now, the new grade that's occurred here, which I saw that they did some grading, but I hadn't been involved in any, I hadn't talked to the town or anything, my first time on this. On this location right here, which is to the west of the home, drainage that used to occur from the home itself and sort of some of the area in the backyard, other than it being tempered by the trees that were there or being slowed down by the vegetation, this area sort of naturally ponded, and I'll use the word ponded, but it would collect water that would act sort of like a filtration and a little bit of a absorption basin. So it didn't go running down the road and end up across the street here on our property. We're not a water course. So my biggest concern is that, that obviously the amount of disturbance on this property, you can see, including this and this disturbance, is way beyond what is allowed under the Oak Ridges. So other than that, the actual drainage that's there, because there's no report from an engineer in terms of the water movement, where it's going to go, from a practical point of view, there's definitely more water flowing. The topography's become smooth, it's grass, it can flow better. When the weather gets cold and it becomes icy, it just flows over the surface. And some of it ends up on the adjacent property, which I believe is the same fellow's property next to here. And that's been raised a little tiny bit when they did their driveway, but it still runs down this direction and ends up in our property where it didn't before. When this subdivision went in, I was part of actually went to an OMB hearing, which I was involved with, and we prevented any water from this new development ending up on our property. It was quite a challenge, and engineering firm involved, because we're not a water course, and they adhered to it. So everything from here drains back into the back of this property into a new drainage catch basin. They've created a big siltation pond back here, and then it absorbs in. So that's my biggest concern. So past that, I don't want to get long-winded, because what's done is done, and that's up to the town in terms of what they do on remediation. But those are my comments. And if I know it says in the report that that there has to be, reassurance that the drainages that existed before the changes have to be maintained after the changes that have been done in the grading. So I haven't done that deep an analysis on this, but someone should and would, and that probably would have to get dealt with in some way, I think, here in terms of the grading, just to prevent that water from running off. And that's the extent of and I didn't know, when I saw the sign on it, I didn't know what the purpose of it was. I didn't know if they were intending to put in an application for building something. I didn't realize that. I just read this, what it's about. Thank you.
Thank you for your comments.
And
Just,
Well,
just,
sorry,
just,
just one final thing, I meant to say it before, take 2 secs. You can see here pretty easily, and I actually didn't see it before because it's hard to tell, the difference between, if you look at this is that same view with the home and the lack of trees and grading in here versus the previous view, which is this with all the area treed and all this area treed. You can see quite a difference between the 2 pictures. So that's it.
thank you for your comment. Just before you leave, I'll just, in order to avoid you coming back and
Thank
forth,
you.
are there any questions from just to this gentleman? No? Thank you very much
Thank
for
you.
your comments.
Thank you.
Is there anyone else from the public that wishes to speak? Okay, seeing none. I'll then turn to the committee if there are any questions or comments. Yes, go ahead, Clarence.
Yes, through the chair, a question for the agents of the applicants. Ms., you're aware that as the applicant, you bear the onus to provide us with information and evidence to support the 4-part test as set out in Section 45(1) of the Planning Act. Can you please take us through your submissions for the applicant on how this application for minor variance meets all 4 parts of the test as enunciated in Section 45(1) of the Planning Act?
So, yes, I do acknowledge that. I am only unfortunately able to speak from an environmental perspective. The draining issue, we are aware of that. That was a concern that when we met with the township and the Conservation Authority that had been brought up. What we found was the amount of grading that happened on the site through some soil test pitting that we did through hand augering was not very deep. And we were trying to figure out exactly how that got displaced over the course of the entire site area that was disturbed. I recognize the comment from the concern from the adjacent owner. I think that with maybe some modifications to that front grading, those drainage issues can be alleviated. The issue with the adjacent subdivision, that was also recognized in our field assessments, and we noted that a lot of ponding is actually occurring in the back corner. We had determined possibly as a result of that adjacent subdivision. So without that retaining walls and additional roads that were coming in, we don't believe that a lot of that water would have been ponded there as it may be doing now. We noticed that sort of sink. So unfortunately, those are the only things that I can speak to with regards to the test that you're referring to.
Thank you for that. What I really want to focus on, and I think you know why I'm asking, I want to go through the 4-part test, and I want your submissions on each one. So why don't we do it this way? Can you please provide us with your submissions on how this application of a minor variance maintains the general intent and purpose of the official plan? We'll start off with question number 1. Please provide us with your submissions.
Right. So as outlined in our Natural Heritage Report, we did the species at risk assessment, we did the environmental component with regards to the key natural heritage features, and those, in our assessment, we determined that it complies with those policies.
And which policy are you specifically referring us to?
Grab my report. So, for example, with regards to the key natural heritage features, the woodland was not, in our opinion, from our assessment, fully encroached upon. So yes, some trees were removed, but through our determination, some of those trees were part of the landscape of the rear yard. They weren't the actual component of the woodland. We have some modifications within the natural heritage tree protection zones as part of that fill. So unfortunately, we recognize that, but there is actual tests that allow those encroachments to occur, provided that a no negative impact be demonstrated. And what we determined through our assessment is from that particular part of the policies is that there was no environmental impact because the features stayed the same.
Okay, so which specific policy are you referring us to?
I can't refer to that at this time. I'm sorry, I'd have
Okay.
to look
And
back
again, I want to remind you that as the agent for the applicant, you're the one who has to convince us how in the position of the applicant you can meet the four-part test. So my question to you, and please help us understand and refer us to specific provisions and policies that would allow us to determine how your application meets the general intent of the official plan.
So are you referring to the official plan in terms of the Oak Ridges Marine conformity?
I'm referring to any and all submissions you have in order for us to cross the first part of the four-part test. So help us, provide us with your submissions so we can understand.
So when we prepared this environmental assessment report, again, I know I'm here speaking on behalf of the applicant, but I can only speak to the environmental conditions of the site. From a policy perspective, we looked at it from the OP, and there are no policies within the OP that prohibit the development within these features, provided that the natural heritage assessment report shows that there's no negative impact. And we believe that we've demonstrated that through our EIS.
And just looking through the materials that were submitted as part of the application, and all I'm interested to know is where within the application does it speak to any information to suggest that the application meets the general intent of the official plan. And I'm struggling to find, from just doing a search of the material submitted, a reference to the word general or a reference to a word intent in the materials. So that's why I want to give you this opportunity to give us your submission so we can understand how it will meet the first part of the test. And then we'll have to go through that for the second and the third and the fourth. But let's start with the first.
So, for example, like under OPA 48, with the estate residential, we looked at the landform conservation, we looked at those types of components, and we do recognize that the area does exceed those thresholds. The issue, unfortunately, with this particular application is the work has been completed. We're not talking about a proposal to do the work. So it's tough for us to try to kind of backtrack and sort of see that. So the issue is, do we remove all of that fill? What type of environmental effect would that have to put it back into this natural state? Based on the fact that it was a rear yard, it was a landscaped area in the rear yard. There was no encroachment into the adjacent wood lot, which is a pine plantation. There was no effects on endangered or threatened species. The drainage, we recognize, might have been an issue, but we do also recognize that there is the challenges of the adjacent subdivision that is also creating some of those drainage problems. With some minor corrections, those intent of that issue can be corrected and fulfilled in terms of the environmental effects. As typically stated in the official plan in terms of showing no negative impact.
And can you please respond to what's contained in the staff report under planning comments A, which is the staff's opinion with respect to the application of OPA 34 policy 3.3.2. What response do you have in reply to the opinion of the staff that the removal of the existing trees and vegetation to accommodate the placement of fill and regrading do not maintain the intent of the official plan?
We recognize that some of the trees have been removed. If you look at the historical aerial photography, you can see that there is some removal, but we do have to recognize that the trees that were removed were part of a landscaped rear yard. And unfortunately, I don't know, we didn't do the assessment ahead of time. I can't go back in time to figure out which trees were actually removed. What we saw were stumps of small cedars, some Scots pine, and some small shrubs. And our aerial interpretation going back to that is we feel that those were not significant contributions to the woodland natural feature. They were part of the vegetation buffer management zone. So we feel that the removal of that vegetation does not affect the woodland composition. It doesn't affect the interior forest canopy. Therefore, it doesn't affect the ecological function that that woodland would have on the landscape.
All right, anything else on the first part of the test?
No, not this time.
All right, so let's go to the second. Can we please have your submissions with respect to whether and how the application meets the general intent of the zoning bylaw?
So the intent of the zoning bylaw, the applicant recognizes that he made a mistake when he did the filling. He is trying to correct that by trying to make his site in compliance, which is why he's asking for the variance. The fact that he's asking for the variance obviously is that he didn't or he couldn't meet the zoning bylaw.
In the staff report, there under heading B, in the heading, planning comments under B, it is noted by the staff that there's insufficient information to determine if there's a different feature boundary than Schedule B of the zoning bylaw. And then in the third last paragraph under that subsection is indicated that there's missing information regarding the type and general size of trees that was removed from the site. What response do you have to the comments made by the staff?
So we recognize that, but what also has to be recognized is we used aerial photo interpretation in our site assessment, looking at the ground and what was there. I cannot provide that information, and that information will not be able to be provided for the future because it's just simply not there. We had asked the client to provide some of that information. There were no photographs, so we have to rely on the expertise of myself, who's a certified arborist, as well as the aerial photography, which when we were there showed small shrubs and trees, small cedars, and the occasional Scots pine,
And so,
based on the vegetation that we assessed in the field.
so just make sure I understand, you're acknowledging that there is insufficient information for the town to determine if there is a different feature boundary than Schedule B of the zoning bylaw?
No, I am acknowledging that we don't have enough information on the number and the size of the trees that were cut. But we do have, if you look back at those aerial photographs, you can actually do that delineation. So we did a GIS exercise where we did some zooming in to try to figure out if we could figure out what that line, and looking at the tree canopies of those trees, and we feel that the feature as represented today is fairly similar to what was done pre-grading or pre-fill. So there hasn't been too very significant difference in that feature boundary. So we're very confident in the feature boundary that it's very similar as it is today as it was before the fill had occurred.
And But how about the type and general size of trees that was removed from the site? I take it you wouldn't have information on that because you weren't there when it was removed, I take it.
Exactly. So we just have to use what we saw in the vegetation on site. So we did, obviously, I can't encroach onto adjacent properties, so we used binoculars. We looked at some of that vegetation, and it's an older sort of plantation, so there's not a whole lot of understory trees. It's some small seedlings and saplings. And we noticed quite a few, like I said, cedar stumps, eastern white cedar stumps in and along the edge, and some scrubby, like honeysuckles and things like that. So that's what we used to base our assessment on, to say that it's mostly shrubs and smaller trees, and Scots pine, because that would have been representative of the site at that time.
Do I take it, whether you can let us know, there's any disagreement to the staff's view that the total area of disturbance on the site is 18% greater than that permitted by the zoning bylaw?
I can only go by with the assessment that was provided in our natural heritage in terms of our calculations. That was based on information that was provided to us by my client, and it sort of in situ field fitting. We don't have the exact number. We had tried to get that information, but there's no records. There's no information on trucks coming in, on fill amounts coming in. We had to go by what we saw in the field, and our map and our calculations that are done through our NHE is based on those field site assessments.
All right, let's go to the third part of the test, which is whether the application is considered desirable for the appropriate development or use of the lot. Please provide us with your submissions.
So given that at this time, it is my knowledge, and the knowledge provided to me by the applicant, is that this was a mistake, that there's no pools, there's no development being planned on the site. It's just a matter of some minor grading that he tried to do in his backyard. So I can only go by that information that is provided to me by the applicant. So in my professional opinion, based on the information that's provided to me, I have to say, yes, it does meet, because it's not a significant alteration to the site or development.
Anything else on the third part of the test?
No.
And how about the last part, which is whether the proposed variance is minor in nature?
In my opinion, based on what I saw on site, it is minor. Yes, we recognize that some grading had occurred, but there wasn't large amounts of fill that we were able to see. There wasn't a transition zone that's typical when large amounts of fill are placed. We did notice a little bit of maybe 15 centimeters or more along the base of some of the trees that would indicate that kind of amount of fill. What I'm seeing on adjacent properties, for example, I do not consider this a significant alteration, no.
And what do you
Based on the
say?
information that's provided to me.
What do you say in reply to the comment of the staff that the efforts were not taken to mitigate impacts to existing vegetation, and that a further decline of 16 additional trees is anticipated?
So we're happy to work with the town in terms of any sort of restoration or replanting with regards to what's being proposed. What reason why we use those numbers was because that was the number of stems that I could count. I could physically count and make an informed decision about the number of trees that I felt that were removed from the site that were either 10 centimeters over or greater, which is very typical with tree cutting bylaws and things like that. If the township feels that, you know, more vegetation or more restoration should be proposed along the edges of the property or at the front, then that would be something that I'm sure that my applicant or the client would be willing to discuss.
The trouble with that is, you know, the staff put in the report that the efforts were not taken to mitigate. There, as I understand, there was a notice of violation issued and the like, you know, back in 2017. Is that right?
There was a violation, so my firm was retained once that violation, I guess, was issued.
All right. So that would have been when?
We were retained this year, so we were retained earlier in January.
So between the time when the notice of violation was issued and the time when your firm was retained, is it fair to say that nothing was done to mitigate the damage and the impact to the existing vegetation?
At the time, I understand it as relayed to me that he didn't know what he had to do. He wasn't really sure, which is why he retained us to provide the NHE and to help him work through the application. We've been working with the township and the Conservation Authority ever since to try to rectify the issues on this site.
And what, if anything, has been done between the time of your involvement to now, in order
He
to
hasn't done
mitigate
anything.
the impact?
So he hasn't done anything because he wanted to make sure he had approvals first to do anything on site. So he didn't want to make the same mistake that he did before in terms of doing site alteration without approvals.
That is, the alterations or work in order to mitigate the damage has already been caused to the existing vegetation. Is that clear?
That's true.
Okay. Is there anything else that you would like to add concerning the four-part test that you, on behalf of the applicant, is required to meet?
No, I think that's sufficient.
Okay, thank you very much.
Just before other questions come forward, just for clarity to staff, can you just reconfirm the date of the notice of violation? Do we have that? I know I saw it in the report, but the agent mentioned 2017. And while staff are double checking, and I want a little bit more clarity on when you were retained, is it 2018, 2019? Okay, that. Thank you.
Through the chair, as outlined in the report, in the proposal section, there was a notice of violation issued in August 2017.
Okay, terrific. Yeah, so I just want to thank the vice chair here. So it appears in the report that the notice of violation was issued in August of 2017, and that the notice of violation issued in November of 2017 required that the property owner restore. So you've got a notice of violation and then probably a follow-up between August of 2017 and November of 2017 requiring that the property owner restore the land. So there's is that a continuance of the notice? Is that how I'm reading that? Am I reading it right?
Through the chair, it appears to be continuous.
Yeah.
That I'm not 100% sure on, though.
Okay. But we do know that there was a notice of violation that does go back to August of 2017.
Per staff report, that's correct.
Perfect. Okay. Thank you. Just dates are running around here, and I just want to make sure that we're all consistent. Okay. Thank you for the clarity, staff, on that, Matthew. I'll move on to any other questions or comments from committee. Daniel?
Through the chair, I just want to talk about one point specifically, and you sort of broached it earlier, but it has to do with the fill. Do you know at this point how many cubic meters have been brought in for the fill?
So we, when we had our meeting with the Township of Aurora and the Conservation Authority, that was one of the questions that came up, that we tried very hard to try to figure out how much fill was actually placed on the site. And unfortunately, we could not obtain those records. So what we did was,
So you couldn't find out how many trucks were brought in, how many dollars were spent?
we tried.
2.5 years later, and you
I-
still can't get that information?
Unfortunately, I can only speak to information that was provided to me on behalf of my client, and we were told that that information just didn't exist.
Sorry, who told you that information?
My client,
So the
the
property owner?
applicants, yes, the property owner.
So the property owner does not know how much he spent to have this done? Because I'm sure he didn't do it himself.
I do not know. I can't answer that question. I'm sorry. What I do know is what we,
No, but if you do have information, you can certainly come forward. Not at this point, but we'll come back to you, though. Thank you for putting your hand up. The chair recognizes that and your efforts to help us out.
Sort of brings up a odd scenario, because I don't know if that person represents the public or the applicant.
We'll ask when he comes forward.
It just impacts, well, anyways.
so what I can tell you, what we did do, in lieu of not having that information, like I said, we had a soil hand auger, as well. The advantage of us going to the site and looking at some of the areas that were disturbed because it hadn't been grassed yet, you could see the area of fill. So we knew the physical area, which is mapped in our natural heritage report, and we knew approximate depths from doing those hand augering. But it is challenging because we are talking about an already pre-existing lot. So it's not like we're talking about a woodland with native soils underneath. We're talking about like a disturbed backyard. So, and then also we had the adjacent work that was being done by this subdivision. So there was fill and retaining walls, essentially not properly being contained by that subdivision coming into the site. So we did the best that we could, trying to determine that area. So that area that's presented in our NHE and that approximate depths are what we have to go by.
So I guess my final question, was the applicant living at the residence at the time of this work?
I don't know that answer, I'm sorry.
Okay. Thank you.
Michelle.
Through the chair, just a couple questions, and again, building on my colleagues' questions on the 4 tests. In the staff report, aerial photography of the years before and then after the site alteration shows that the site previously contained a number of deciduous trees, and you had mentioned just conifers, spruces, a couple straggly pines, and a bunch of little bushes. In addition to that, the Lake Simcoe Region Conservation Authority questions and challenges your report in that they take a look at the aerial photography and indicated over 400 square meters of tree removal on the property between 2016 and 18 were done. And as part of the Town of Aurora's official plan policy, 12.5.2F, the removal or destruction of key natural heritage features by unauthorized development or site alteration is prohibited. The owner did get a notice of violation in 2017. That's over 2 years ago. He let the dates in November in terms of restoration. That was blown off. Nothing was done. And here we are 2 years later. Is there anything you'd like to comment?
I think you summed it up very, very clearly. The only part that I would have is, so yes, there maybe was a little bit more deciduous, but we didn't seem to find that many deciduous trees when we were on site. So that may be the case through some of the aerial, but it's always difficult to tell because of the shrub component. So when we were there, there was things like buckthorn. So when we do the aerial interpretation, it's hard to know if that shading that we're seeing in those aerial photographs are actually, large mature oak trees, which we did not indicate, and the vegetation on site didn't indicate that, or whether they were just a landscape component. Unfortunately, that work was done beyond our ability to see that information.
Okay, through the chair, I must say that after looking at the aerial photography of before in 2016, 2017, 2018, and what the site looks like today, I was absolutely gobsmacked. So that's all for me right now until we have our other person comment.
So if you want to take a seat for a moment, because what I'm going to do is I'm going to hold off on my questions to you. Normally, procedure in the room is we ask for members of the public to come forward before we get into questions from members of the committee. However, I think Daniel Lajeunesse has had a good question, because I was going to ask the same. So I will ask if there was someone here from the public that wishes to speak to the committee. I will allow that. So, sir, I know that you did put your hand up. You may be able to help us answer a question. So if you could come forward, let us know who you are and where you live and any other relevant information you wish to share.
Thank you. I'm one of the owners to that property at 107 Ridge Road. I live at 125 Ridge Road.
Your
My
name?
name is Peter Narduzzi.
So you mentioned, are you one of the owners of
107 Ridge.
107?
Yes.
I see, okay.
Okay, so I can answer his questions.
So in terms of amount of fill that was added,
Yes,
do you have any idea as to?
I would think about 30 to 40 truckloads. Yes, small truckloads, because it was done in May, so you couldn't have big trucks on the road at that time.
All right, so if that was the only question that you had of the gentleman, okay,
Also,
so,
he asked about money.
Well, I was trying to find the equivalent.
Well, there was no money because we did all the work ourselves. So, also, I would like to say that that property was a disaster, and we improved everything into that house. We cleaned it up. It was a shambles, and we cleaned it.
so
Meaning that there was a back porch, was a disaster, rotted. Just no one looked after that property.
okay,
And not to say we cleaned it up, because I live on that street, and we did a good thing there. And in the amount of trees, we took down some trees because they were all around the septic tank, and we were have problems on that septic tank with the roots going down. So that's why we removed some of those trees there.
how long have you owned the property, if I can ask?
2017,
So you purchased it in 2017?
yes.
And because that's one of my questions, why were the trees removed in the first place? You've answered
I
that?
have one of the partners, he's old, and he thought he was king. So he did what I said. I said, you're not allowed to do these things after the fact. So that's, we trying to fix the problem. He noticed that he made a mistake in doing that instead of getting a fill permit, because he wasn't unaware of that, because he's an older gentleman.
So how long have you lived on the street itself?
More than 10 years.
So if you are a resident of Aurora for more than 10 years,
Yes.
you didn't have any inkling about a tree bylaw or?
We did, he started to do the work, I'm doing my own thing, so he started to clean up. And in regards to the lady said that's 2017, we couldn't find anyone to help us out. That's why it took so long.
I see.
And also, the town took a long time to get back to us. That's why it's more than a year. So it is our fault, but also the town. We made many phone calls and we weren't getting responses. And that's why it's taken so long.
So even after the notice of violation?
We couldn't find anyone to help us out. That's why I'm lucky that I have a good friend and we found this company to help us.
I see.
Nobody wanted to touch it.
Here at the town of Aurora?
Not to touch what our mistake was. Nobody wanted to go to do something for us.
Oh, I see, okay.
Yes.
So you didn't have problems getting in touch with the town of Aurora, it was getting in touch with someone who could help you?
Yes.
All right, thank you for that clarity, sir, I appreciate that. Daniel, did you want to go back and, I think what you're trying to do is get a scope of the magnitude of the amount of fill that was added? Correct. And, okay, did you have a follow-up question or comment on that? Either to the co-owner?
Oh, no problem. Thank you very much.
Thank you for coming forward, I appreciate that. So we've answered why the trees were removed. I think there was an issue with the septic. And if I'm not mistaken, the amount of fill that was added was to address some of the drainage issues, which by default may have created a drainage issue to the neighborhood or to one of your neighbors from the comments that your neighbor has made. I want to go back to the agent, please. If I can ask you a question here that I have. Can we pull up the graphic in your report that shows where you're going to mitigate? Where are the areas that you're going to, or that you had proposed to mitigate?
For the restoration.
Yeah.
Sorry, I don't have a color version.
Yeah, a colored version actually would help,
I know.
I think. No, that's okay. I know that it's there, but if we can put that up, please. That's fine. And I think the neighbor had something similar to that he put up earlier. There's a hatched area at the south end of the property there, I guess. Is that the area that is proposed to be part of the mitigation? Can you run me through that hatched area if you don't mind?
So yes, that's the area where we were proposing to put a mix of deciduous and some seedlings and some caliper trees. The reason we chose that location was because of screening to the adjacent development, but also trying to create a little bit more of a habitat restoration area that would be away from any potential disturbances of the existing residents.
You mentioned earlier that part of the problem was created by the development, the subdivision development, and there's a sliver there that goes up along the roadway and you mentioned that there was, because of the difference in the elevation and the requirement for the subdivision to drain everything away from the existing residents, your client's residence there, that your concern was the stability of that slope and what had already infiltrated the property?
No, it relates back to the issues of drainage. And I think the owner, one of the owners actually pointed to it as well, is what we noticed when we were on site is that there was a large retaining wall, and that there was some ponding that was occurring behind that retaining wall. And so water sort of ponding there. Recognizing that we're not going to, because of the existing topography, not necessarily the fill issue, that's a low area of the site to begin with, that it's also essentially an unusable space that would provide good opportunities for restoration plantings. So it wouldn't necessarily get super dry. We could plant some screening. There's no screening to the adjacent subdivision either, so that would provide some refuge opportunities in that corner. The challenge with going up the side here, for example, is the existing tree canopy, and so it also reduces the open space of the backyard. So we didn't want to completely restore the area, because that's not what was being proposed to us anyway. It was to provide enough compensation to maintain some of that continuity of what was there previously.
So here's where I have a problem. So I'm going to assume then that the future plans would be for the balance of the area there that's been filled and site altered would be to put grass down or outdoor amenity spaces, be it formal or informal. And the problem that I have is, like my colleagues here, we were looking at 2016 aerial photos, and I looked at the boundaries of the area that have been identified that highlight 401.02 square meters of area there that certainly drive the areas affected well beyond the 25%. And yet I don't see any mitigation outside of what I'm looking at on this plan that comes anywhere near the limits of the boundaries that have already been identified as areas that have been affected. And further, we've got an inconsistency between the number of trees that we think have been cut down versus what's contained in your report. And I go back to the aerial photographs and I think, gosh, if we were even close in my mind, I wouldn't be struggling with it quite as much as I am. So I certainly have a problem with that. I am not sure that should the committee approve the variances, that there's enough in the conditions that would cover that, but that would not be our problem. That would be staff's problem to wrap their head around. But I want to draw attention to Appendix A, which is recommended conditions of approval. If we were to approve, have you looked at all of these conditions?
Yes, I have.
And would you and your client be prepared to accept those conditions?
Well, actually, since one of the landowners is here, I will defer that question to the landowner.
So I'll ask then the landowner, have you read all of the reports and the staff reports and the conditions that are part of that?
No, I haven't. We have a gentleman that hired this lady to help us out. So you're grasping
Yeah, please come forward.
You're grasping something that I'm not familiar with. I'm just I work in the construction. I'm a painter, general contract. So
Okay.
I can't wrap my head of what you're asking for.
Essentially, what they're asking you with regards to the conditions, would you be prepared
Yes,
to restore most of or greater than
sure we are.
50%?
Sure, sure. Whatever, like I said, we made a mistake, and whatever the town asks us to do, we're going to do it.
Okay, I'm not sure that you're one owner. How many owners are there?
There's two other.
Two others. So you can only speak for yourself. You
Yes.
can't speak for the two others. And I'm a little bit. I'll ask the agent. Did you get a copy of the staff report?
I did, so.
Did you not refer that staff report with the appendix and conditions to your clients?
We did, and so the information that was relayed to us was that we wanted to move forward with the restoration area as presented, that they would be willing to work with the town to talk about increase in that restoration area, but that's something that they was hoping to do outside of the Committee of Adjustment meeting, once the minor variance was approved.
Thank you. If you want to speak to this. So, any other comments? Because I've kind of covered maybe some new ground here. You can only speak once, unfortunately, sir. I think I know what you're thinking. You were living on the street for quite a number of years, and the trees that were there were significant trees before they were cut down. Perhaps that, I'm not sure, but unfortunately, and I apologize if you didn't see the report. Yeah, I know he's yeah, there's, correct, yeah. So, okay, let's start with that, and maybe you can, you can't speak, but we're gonna try and cover off what we think you might be thinking, and you can nod your head if we are in the right.
Okay, so through the chair, in this diagram, you show the screened area in terms of some of the restoration that is being planned. And we had a comment back from our citizen, a resident, indicating that there were pooling and water coming down due to that side piece, right? And there's no restoration or any mitigation to address any pooling or flooding or water issues as a result. Because you sort of see the side of the house, there's nothing being done there.
Is that correct?
Is that, okay?
We weren't aware of those additional pooling issues. So when we were doing our site assessments, we didn't see that pooling. We have to also acknowledge that this year was a really wet year, so from a rain period, so there's a lot more water on the landscape. If that's something that the township would like to entertain, I'm sure that my client would love to discuss options of additional restoration or vegetation areas.
We can't really do that. Clarence, I think you had a follow-up?
Yes, through the chair, and the chair asked you the question as to whether the applicants would agree or disagree to the 8 recommended conditions of approval as contained in Appendix A of the staff report. Do I take it from your response to say that the applicants do not know whether they will agree to the conditions as recommended by the staff should the committee decide to approve the application?
Unfortunately, when I was asked to come and speak at this meeting or answer questions today, the owners or the 3 owners of the property and the liaison between the owners and myself, I don't believe they had a conversation or they hadn't discussed with me what they would like to move forward with. So I can't,
Can't speak.
at this time, say that the applicant would be willing to do that, but I'm sure that they would be open to those discussions with the township.
So the answer to my question is no, you don't have, the applicant has no position to take with respect to those conditions recommended by the staff as a condition to the approval of the application, and as specified in the report dated December 6, 2019. We're 6 days after the issuance of the report. The applicant has not considered the recommended conditions and have no position or response in respect of those conditions as recommended. Is that correct?
Not entirely. They recognize that there are conditions, for example, restoration. I don't believe that they fully understand what the township is actually asking for with regards to restoration on the site. I think that it would be very helpful to have that discussion between the township and the client outside of a letter, because it needs to, I think, visually be conveyed. And unfortunately, I didn't have time to prepare that information to my client before meeting today. So I have to defer my answer to that question.
But you appreciate that this is the application here today, right? We're not
I do
looking to
recognize that.
deal
Yes,
with
I
it
do.
at any other time other than today.
I do recognize that.
And the report included conditions for the applicant's consideration, and they didn't consider the conditions as recommended and decided to proceed with the application today. Is that fair?
That's fair.
Okay.
Yes, you're right.
Thank you.
So in the event that this committee approved it, those conditions would be fixed,
True.
and they
Yes.
would have to comply. One final question for you, and I meant to ask it earlier while you're here. Is the level, the current levels, where the property elevations have been altered, in your opinion, are they appropriate? Is the current level of the land, the way it sits right now, is it appropriate for the property, in your opinion?
Sorry, I'm not sure what you mean
So-
the levels of fill?
Yes.
Oh.
So those 30 to 40 trucks of fill that have been added, is in your opinion, the way it has been distributed over the property, is it appropriate? Is there, in your opinion, does that help alleviate drainage issues that pre-existed? Does it improve the septic conditions? Is it appropriate?
So I can only speak to the conditions that I saw on site. I don't know what the conditions were like prior to. So-
Water under the bridge, the
Yeah.
way, it doesn't matter. I'm talking about today.
So what I saw on site is that the level of fill is appropriate. So it's distributed, it's even, there's not a lot of hummocks and hollows. It doesn't significantly cause impact to the woodland piece. The challenge is also the adjacent development. So there is some water ponding that's created, but it's in my opinion, what I saw, that's a direct effect of the adjacent of the retaining walls and things that have been put in, and some of what I saw, insufficient in sediment fencing and pushing over of material onto my client's property that I don't believe was fully respected, that we were noted. And if I was going to speak to a bit more of that, I could show some photographs that show some of that material that was pushed over that's creating that issue. But with the core area of where the fill had occurred, it is, in my opinion, respectful of that existing landscape.
So 2 points. There's 2 points here. What happens on site that your client has done relative to conditions that were possibly created by the subdivision have no bearing. If there's an issue there, it's between 2 property owners. And there may be action that you can take in order to mitigate damages to your client's property. That's issue number 1. Issue number 2, and the reason I asked you that question is because it is contradictory to staff's report in section D, where it asks, again, it comes back to the 4 tests. The proposed variance is minor in nature, and the last sentence in that paragraph says, actually, I won't take it out of context, I'll include this sentence before, the addition of fill and regrading within an area of approximately 1,353 square meters, just shy of 15,000 square feet, represents a large proportion of the existing lot. In addition, efforts were not taken to mitigate impacts to existing vegetation, and the further decline of 16 additional trees is anticipated. If I read that correctly, what it's telling me is that the amount of fill that was added and the regrading of that fill around the property has resulted in the further decline of 16 additional trees. It's anticipated. So you would take exception to that comment because you've just told me that it is appropriate. How can it be appropriate if it's anticipated that 16 additional trees may be affected by the new grades?
So the way it was done, you're right. That was actually our recommendation in our report. So the area that we're talking about with regards to the trees is this area here. This is where we noticed those were sort of existing pockets of trees that had sort of fill on them. So the mechanism in terms of the way that the fill was physically placed is not is not finessed. So some of this material was placed on tree roots and things like that. But the area of the location, based on the information that was provided to myself by my client, and the area in terms of the location, an existing residential property, that is what I'm referring to as minor, but I do acknowledge that the mechanism of the placement of fill is not minor in essence.
Okay. So I just full stop for a second. I want to thank you. When this committee receives these variance applications, all of us typically go out and have a good look at what's going on the property. And when we review these and we see a staff report that does not support the application, I like to, as chair, give the applicant as much time as they need in order to present their case, because in these particular cases, it's sort of we putting the apple or the cart before the horse, and the work is done to a large extent. There's some mitigation that would have to take place, but you've done a very good job of answering our questions to the best of your ability, and I appreciate that. And I appreciate the gentleman, one of the owners, for coming forward and trying to help us wrap our heads around this one, because in my opinion, this one was a little bit out of the ordinary for this committee to be reviewing something of this nature. So I want to thank you. I guess at this point, I'm going to look to members of the committee, remembering that we have a staff report that does not support this application. In fact, it looks at the 4 tests and essentially says that it doesn't meet any of them, and that there are some conditions here that that I think Lake Simcoe Region Conservation Authority would probably, having spent more time with your report and reviewing the circumstances in this case, would probably add more conditions from the emails that we have seen, and I hope you've seen as well.
Yes. Yeah.
So I'm going to look to the committee here for a recommendation and a motion, please. Clarence.
Yes, through the chair, I move to reject the application being MV 2019-25A, B, and C on the basis that the application does not meet the prescribed tests as set out in Section 45, Sub 1 of the Planning Act. In that, in particular, the proposed variance does not meet the general intent of the official plan, as the removal of existing trees and vegetation to accommodate the placement of fill and regrading do not maintain the intent of the official plan. Secondly, the proposed variance does not meet the general intent of the zoning bylaw, given the missing information as specified in the staff report concerning whether there was any information to determine a different feature boundary than Schedule B of the zoning bylaw, that there's missing information regarding the type and general size of trees that was removed from the site. Thirdly, that the application for the proposed variance is not considered to be desirable for the appropriate use of the lot, for the reason as specified by the staff that the restoration plan as proposed is not adequate, as it results in the expansion of the residential use in the rear of the property, includes planting not only along the perimeter of the site in particular. And finally, and I believe that's acknowledged by the applicant, the proposed variance is also not considered to be minor in nature because the efforts have not been taken despite the issuance of the notice of violation in 2017 to mitigate the impact to existing vegetation, and the proposed work would result in a further decline of 16 additional trees, and that was anticipated and that was specified in the report that's submitted by the applicant as part of the application. For those reasons, I move to reject the application MV 2019-25A, B, and C.
Thank you. Is there a seconder? Seconded by Michelle. So I'll call the question. All in favor of the motion as presented? And that carries. Thank you. So you will be receiving notification of the committee's decision. And thank you very much for your time. So moving on to the next item on the agenda, which is an application for consent for Surreal Holdings Limited, 100 Englehart Drive. This is file C 2019-12. This application, in this application, the owner of 100 Englehart Drive, which is the subject property, has submitted an application for consent to sever a portion of the lot and convey it to the abutting property to the west, which is 90 Englehart Drive. We have comments from agencies and departments circulated. So the building division preliminary zoning review was completed, and the plans as provided indicate compliance with the requirements of the zoning bylaw. So 100 Englehart Drive is located within the generic regulations of the Lake Simcoe Region Conservation Authority. Therefore, an approval may be required there. Engineering Division has no concerns with the subject consent application. Operational Services Division and Parks, no formal comments, concerns regarding the above application were received. Central York Fire Services, no comments provided at the time of the writing of the report. Legal Services, the same, no comments received. The Region of York has completed its review of the consent application and has no comment. Lake Simcoe Region Conservation Authority, so they're noting that a portion of 100 Englehart Drive is partially governed by the Lake Simcoe Region Conservation Authority under Ontario Regulation 179-06 of the Conservation Authorities Act. This is representative of apparent valley lands characterized by the steep slopes associated with the tributary of the East Holland River, located on the adjacent lands to the north. It goes on that within the settlement area and Category 2 and 3 landform conservation area under the ORMCP contains KNHFs, which is valley lands, for example. And then based on the available mapping, it's noted that the lands to be severed do not contain any key natural heritage features, and based on their review, it is determined that the proposal is generally consistent and in conformity with the natural heritage and natural hazard policies of the applicable provincial plans. Is the agent or owner with us this evening? Good evening. Welcome. Thank you for your patience.
That was a complex file, so hopefully mine's a little less complex. I am the agent. My name's Mark Stone with MLS Planning Consulting. I'm here on behalf of the owner of 100 Englehart Drive. Sorry, are you flipping slides? Okay, thank you. Just give a quick overview. The subject property is located on the north side of Englehart Drive, east of Industrial Parkway South. The property is approximately 4.2 hectares in size with just over 192 meters of frontage. And the property is the home of the Louisville Ladder Company operation. Next slide, please. So my client is proposing to sever 1,355 square meters along the west boundary of the property. You can see it there in blue, and to convey those lands to the abutting property owner at 90 Englehart Drive. 90 Englehart is the home of Treasure Mills. Treasure Mills is a manufacturer of healthy and allergen-conscious baked goods that you see in a lot of the grocery stores and are distributed across North America. Treasure Mills is looking to expand their operation in 2020, more than double their size, and they need the additional space for the additional floor area and for parking and so on. Next slide. So I've read the report. We've read the report. And agree with the comments, agree with the proposed conditions that have been set out. In summary, the proposed conveyance lands are not being used by 100 Englehart and are considered surplus to their needs. Adding these lands to 90 Englehart will facilitate this planned expansion, creation of jobs and so on. It's a good news story for the community, I think. And if approved, 100 Englehart and the expanded 90 Englehart will continue to comply with the town's zoning bylaw. And then lastly, the expansion at 90 Englehart will be subject to the town's full site plan review and approval process. That's my brief overview. If you have any questions, I'd be happy to answer those.
Thank you very much. The room is vacated of members of the public. So, are there any questions from anyone around the table? I did this afternoon ask staff to flip a copy of the proposed site plan because when I looked at the sliver of land, I thought it's pretty small relative to the overall property, and I thought, well, how much could they possibly be adding? And to my surprise, it's more than the existing building, and I was glad to see the site plan that was passed along. I don't know if you've got a copy of that.
I do, and to be open about this, I'm also representing 90 Englehart. We are preparing a site plan application. We're getting close to submission. We've had a pre-consultation meeting with staff, and we're working towards meeting those requirements. Just to your comment, Mr. Chair, you're right, it is a thin sliver, but most of the expansion will be at the rear, which is now paved, some grassed area, but there is some expansion at the northeast corner of the building.
Yeah, I have to say I was quite surprised, and my comment to staff earlier today was, were we sure that that it would meet all of the regulations, parking, setbacks, and what have you, and avoid, or perhaps be looking at a variance there. And my concern at that time was, what happens if they have increased lot coverage, for example? And here we are looking at a conveyance of land, and obviously there's been enough planning at 90 Englehart to know that this is going to work. So, I'm glad that has been undertaken. And as I said, I asked staff to flip us the site plan this afternoon so that we wouldn't have any questions on that vein. No questions, no comments? I'll look to the committee for a motion on this application. Antonio, can we?
Thank you. Through the chair, I move that the proposal of file C 2019-12 be approved as outlined with the six requirements as shown in Appendix A be approved.
Thank you. Seconder? Thank you, Michelle. All in favor?
Thanks
Thank you very much.
Have a good evening.
Thank you. Okay. Now, moving on, we have a request for deferral for items 3, 4, 5, and 6. We've got that numbering. I think this came back from the previous agenda, if my memory is right, because we had this situation before. So what I'll do is I'll go through the minor variance applications by number, and the applicant that requested the deferral. Am I correct, staff? Yeah, okay. So this had previously been deferred as well, if I'm not mistaken. Yeah, all right. So I'll just run through the variance applications. Minor variance application MV 2019-16, Aurora Investments, Inc., 145 and 155 Industrial Parkway South. Minor variance application 2019-17, same addresses. And then we have the consent. Oh, of course, consent application. That's why it had number 4. Consent application C 2019-08, same addresses. Consent application C 2019-10, and consent application C 2019-13, again, all of the same addresses, 145 and 155 Industrial Parkway South. So I'll look to the committee for a motion to accept the deferrals for those items.
Through the chair, I move to accept the applicant's request for deferral of the applications MV 2019-16, MV 2019-17, C 2019-08, C 2019-10, and C 2019-13.
I'll look for a seconder. Daniel, thank you very much. All in favor? And it carries unanimously. Thank you very much. Okay, so that takes care of the applications for this evening. Any new business? Go ahead, Antonio.
Through the chair, I'd like to inform the committee that tomorrow will be my last day with the town of Aurora. I've accepted a development planner position at the town of East Gwillimbury effective Monday. So I want to thank everyone for all their hard work and making my life easier as well. You guys have been great. Appreciate having you guys all on the panel. Definitely keep in touch, and thank you again for your service with the town.
Thank you, Antonio. Yeah, I was privileged to a conversation earlier today, so I was made aware that Antonio had accepted a position. And I guess on behalf of this committee and probably the previous committee, to be honest, Antonio, I want to thank you for the significant contributions that you have made to the operations of this committee, and for your support in providing us with answers and information to the applications that have come forward. And it has been a pleasure having you with the town of Aurora in your capacity here. And we wish you nothing but the best in your new endeavors with EG, and you will be missed by the town of Aurora and by the members of this committee. So I want to thank you. And if I may, ask you to just elaborate then on where we go from here. Is there, I see Matthew Peverini sitting there with a smile on his face, which is, I'm going to assume, a good thing. But maybe I know that we've had this conversation, but for the members of the committee, please.
Through the chair, in the interim, our planning clerk will be doing all the administrative tasks of my position in terms of the circulation of the application, sending out the public notices. That'll all be done by the planning clerk. Any questions in regards to the specific applications, for the meantime, if you could direct them to Matthew, and he'll deal with them appropriately. Our senior planner will be heavily involved as well, to make sure that the process runs along smoothly. Just to inform you guys as well that the position has been posted already. It went up this past Monday, so they're looking to fill ASAP and make sure that keeps running as usual.
So thank you for that information. That's very helpful. I know that you're going to do your best and have done your best to make the transition as smooth as you can. And I have to admit, I'm glad that Matthew, you've been around the committee now long enough. You are very familiar with the workings and very familiar with how this committee functions and what kind of requests that you'd be entertaining and what have you. So if there's anything that this committee can do to help you as well and manage the transition, don't hesitate to let us know. Any other new business? Nothing. Go ahead. Questions are welcome.
Okay, through the chair, just a question. We have our schedule for 2019 in terms of all of the dates and application dates and so on and so forth. Is the 2020 schedule coming out so that we can post that on our calendars?
Through the chair, the 2020 schedule has been. I'll have it sent out to you tomorrow. I'll send it to you first thing in the morning. It's been revised slightly in terms of time frames. It gives you guys more time to review, gives us more time to review and provide the reports on time and as early as possible. So just have a look at the schedule. I feel like it's a better way to move forward with the 2020 schedule.
And just a quick follow-up on that. Has that new schedule for Committee of Adjustment been vetted through Property Standards Committee? Because we've put dates together again for that, and the goal was to have them 2 weeks apart.
Through the chair, it all aligns with Property Stand. Yeah.
Wonderful.
Yeah.
Thank you for that. So seeing no other new business, before I request a motion to adjourn, I just want to take the opportunity to wish everyone at this table the best of holiday greetings and wish the best to you and your families, and have a very safe break and happiest of New Year's, as well to staff. Enjoy the holidays that are soon to be upon us, and all the best for the year ahead. Look forward to working with the town again. So with that, I'll look to the committee for a motion to adjourn.
I move to adjourn tonight's meeting.
Thank you. We are adjourned.